The opinion of the court in number 91-1030, Withrow against Williams, will be announced by Justice Souter.
This case comes to us on writ of certiorari of the United States Court of Appeals for the Sixth Circuit. The respondent, Williams, brought this habeas action challenging the legality of his state convictions for murder and other offenses. Williams alleged that the state court had erred in allowing the introduction of statements solicited from him by the police in violation of his rights under Miranda v. Arizona. The district court agreed and granted relief. The Court of Appeals affirmed. The Court of Appeals rejected the state's argument that federal habeas review of Williams's Miranda claim should be barred under the rule in Stone and Powell, which holds that federal habeas review of Fourth Amendment claims is not available when a state has given a full and fair chance to litigate such claims. In an opinion filed with the clerk of the court today, we affirm and hold that Stone's restriction on the exercise of federal habeas jurisdiction does not extend to Miranda claims. The equitable considerations that form the basis for our decision in Stone do not obtain here. Most importantly, eliminating review of Miranda claims would not significantly benefit the federal courts in their exercise of habeas jurisdiction or advance the cause of federalism in any substantial way. Justice O'Connor has filed an opinion concurring in part and dissenting in part, which the Chief Justice joins. Justice Scalia has filed an opinion concurring in part and dissenting in part, which Justice Thomas joins.
I have the opinion of the court to announce in Brecht against Abrahamson. In this case, petitioner Todd Brecht was serving time in a Georgia prison when his sister and her husband assumed temporary custody of him and took him back to their home in Alma, Wisconsin. A week later, Brecht shot and killed his brother-in-law and fled to Winona, Minnesota, where he was apprehended by the police. He was then returned to Wisconsin and tried for murder in the circuit court for Buffalo County. At trial, Brecht took the stand and claimed for the first time that the shooting was an accident. To impeach his testimony, the state made several references to his post-Miranda warning silence as to the accidental nature of the crime. And everybody agrees this was a violation of a case we decided a number of years called Doyle against Ohio. The jury returned a guilty verdict. The Supreme Court of Wisconsin upheld Brecht's conviction after concluding that the Doyle error was harmless under the standard of harmless beyond a reasonable doubt in the case we decided in Chapman versus California some years ago. Brecht then went into the federal court system and sought federal habeas relief. And the federal district court in Madison granted relief because it thought this violation that had taken place during his trial was not harmless beyond a reasonable doubt. And then the state took the case to the Court of Appeals in the Seventh Circuit, and that court reversed and said that on collateral reviews, after the convictions become final in the state court system, the proper standard for determining whether the error was harmless is the one set forth in another case we decided called Katiakos. And the standard here is more lenient than that in the Chapman standard. And applying this standard, the Court of Appeals concluded that the Doyle violation was harmless. So we are now the sixth court which will have considered this case. And in an opinion filed with the clerk today, we hold that the Katiakos harmless error standard, rather than the Chapman standard, applies in determining whether constitutional error of this type may provide the basis for federal habeas relief. In applying that standard, we conclude that Brecht is not entitled to relief, so the judgment of the Court of Appeals is affirmed. Justice Stevens has filed a concurring opinion. Justice White has filed a dissenting opinion, which is joined by Justice Blackmun in its entirety, and by Justice Souter in part. Justices Blackmun, O'Connor, and Souter have also filed dissenting opinions. It's Wednesday. It is Wednesday. Geez, you're right. Yeah. We have another opinion to announce, which I omitted. It will be announced by Justice White.
And it won't take, and as usual, it won't take long. For the reasons stated in an opinion on file with the clerk, the judgment of the Court of Appeals for the 11th Circuit is affirmed. Justice Thomas, who is joined by Justice Souter, has filed an opinion concurring in part and dissenting in part. Thank you, Mr. Chief Justice.
It's CSX Transportation.
Oh, he's supposed to say that.
Okay, let's pick up where we left off.